counsel? Ms. Pullen? Oh,
Yes.
sorry, Ms. Sutherland? I was
Yes.
looking at my docket, not at you. I apologize.
Either one. I answer to either.
I understand that. Whenever you're ready to begin.
Your Honors, my name is Marcia Sutherland, or Marcia Sutherland Pullen, as the court pleases. And may it please the court, I represent David Alcorn, who is the former husband. When I refer to him, I will try to refer him, not to refer to him by his name, either as the appellant or as the former husband. And I will try to refer to Mrs. Alcorn, who is the appellee, or the former Mrs. Alcorn, as the appellee or the former wife. When I refer to the trial court, I'm referring to the court that entered the final judgment. And when I refer to the hearing court, I'm referring to the court that entered the order that's been appealed.
Okay,
So
thank you.
So I don't confuse people.
Thank you, I appreciate that.
No problem. I was trying to figure out how to keep that straight. Now, the key facts in this case, some things that are really, really important. I know you guys read the briefs. I've watched these online, but I believe it's terribly significant that all of the attorneys who participated in the trial also participated in the hearings.
Okay.
All of the CPAs who participated in the trials also participated in the hearings. All of the documents relied upon by opposing counsel, by the Tarnow firm's expert, and during the hearing were available at trial. They were admitted at trial, and they were exhibits at trial. All of the documents relied on by Mr. Alcorn were also trial exhibits, and they were also admitted at trial. Only one document was not available at the time of trial, and that was the 2016 tax return. Trial ended at the very end of December of 2016. The 2016 tax return hadn't been prepared. And all during these proceedings, the divorce started in 2013, but during these proceedings, the firm that had prepared the tax returns was Thaney and Associates. And he continued to prepare those tax returns using the same methodology he had used since 2011 when he initially began representing these parties. In 2016, Mrs. Alcorn hired her own accountant, and he also testified. The 2016 tax return was provided to Mrs. Alcorn in April of 2016, prior to the final judgment being entered August 2017. During the period that elapsed, and Mr. Thaney testified that he provided that tax return in April 2016. Mrs. Alcorn never answered that question of whether she got it in April 2016, but her accountant, Mr. Nesbitt, said he had the information he sought from Thaney by June 2016. During the period of April to August 2017, the former wife and her attorneys never made a motion to reopen the evidence. They never alerted the court to a fact that they had maybe found some newly discovered evidence. And when the final judgment was entered, they never filed a motion for reconsideration, rehearing, based on the new evidence they claim they found. The reason this isn't new evidence is because what they complain of in the tax returns are the balance sheets that are recorded and put into the records for the tax return. On those balance sheets, the accounting firm, Mr. Thaney, included shareholder loans as an item of the tax return. He had done this every year since 2011, and that was his testimony. What those shareholder loans represented was that the parties had money in a bank account at the close of the tax year, and the money that was in the bank account that had not been distributed, the business bank account that had not yet been distributed or allocated, was recorded as a shareholder loan. As that money was used, the loans dissipated. So each tax year from 2011 through and including 2016, shareholder loans were on the books and records. During the litigation, the former wife and her legal assistant never requested during the trial that the former wife receive any kind of credit for a shareholder loan. Well, the question is, why didn't she? The answer to why didn't she is because she was the one that set up this accounting structure with their accountant, Mr. Thaney. Mr. Alcorn had very little to do with the accounting until the divorce started. And Mr. Thaney prepared the tax returns in 2015. In 2016, Mrs. Alcorn hired her own accountant. And so the reason that it's not newly discovered is Mrs. Alcorn knew of this process all along. And she just never mentioned it even in trial. The other reason it's not newly discovered is because all of the money that was being held in the Alcorn entity's bank accounts at the time of trial, December 2016, all of that money was distributed in the final judgment. There was $131,000 distributed to Mr. Alcorn. And of that 131,000, it was all due to him because the businesses were, allocated to him at a value of $1.85 million. So he took the businesses, those entities are Alcorn Investment and Alcorn Management. There was a third entity that wasn't distributed. That entity was DLA of Naples. DLA of Naples was not a profitable entity. In fact, that entity held contingent debt of $2.1 million. Neither party asked that that entity be distributed, and it was not distributed. The former husband argued throughout that these matters were res judicata and barred. He also argued throughout that the former wife had improperly pled for a set-off because she understood that those shareholder loans have been on the books for eons. The hearing court erred as a matter of law when it failed to make findings of fact and conclusions of law regarding Mr. Alcorn's argument, specifically that res judicata applied, that set-off pleading and practice rules applied, that sanctions should have been entered against Mrs. Alcorn and her counsel if the court deemed that appropriate, that Mrs. Alcorn was in contempt of court, and that the former wife's interpretation of the final judgment that was relied on in court was erroneous, and it was not reasonable within the circumstances of the entire final judgment. Based on this and the testimony from all three hearings, which I'm not going to go into bit by bit, the court should re-examine the issues de novo and grant the motions and fees and costs to the appellant. Mrs. Alcorn took it upon herself to withhold $61,027 from equitable distribution. She was ordered in the final judgment to convey certain bank accounts. The bank accounts that she was ordered to convey added up to approximately $504,000. She subtracted $61,000 and conveyed everything but that. The former husband, the parties were ordered that whomever paid a sales tax allocation that the DOR was assessing against them, that they would split that sales tax allocation. Well, that sales tax was there was an audit of real estate sales tax. And in that audit, the auditors determined that the parties owed a little over $20,000. Mr. Alcorn made a demand on Mrs. Alcorn for payment of her half of that money, which was ordered in the final judgment, and she refused to pay that. So based on all of those circumstances, the hearing court errs as a matter of law when it failed to make the findings and conclusions of law that are necessary to respond to Mr. Alcorn's issues that have been raised throughout. One of the problems was that Mrs. Alcorn never filed a pleading, or she never filed a pleading, she never filed a motion, she never filed anything until after the first hearing on Mr. Alcorn's motions for contempt, the two motions, and the motion for sanctions. She filed that. The hearing took place in October 12th. She filed her first motion, this was 2018. She filed her first motion November, I want to say 30th, but that could be an incorrect date, of 2018. And so she hadn't even made a written formal complaint to the court. And Mr. Alcorn was left with no choice but to litigate it or give up the $61,000 because they just weren't going to turn it around. And she made no effort to even try to pay the sales tax at all. And so he was left with no choice. All of this litigation was caused because Mrs. Alcorn wrongfully refused to comply with the final judgment. And that should require the payment of Mr. Alcorn's attorney's fees and costs. Now, a few more facts that were known at trial that are important. The former wife's accountant testified that the shareholders agreement between the parties required that shareholder loans be reimbursed and paid back upon the transfer of the entity, the sale. The shareholders agreement did require repayment of shareholder loans, but only if those shareholder loans were memorialized in a note, a written note. There was never a note associated with any of these loans that took place from 2011 through 2016. When she refused to pay, when she claimed that DLA owed her money, $4,099, which was part of $61,027, she knew DLA had not been distributed and DLA had no assets. That was completely frivolous claim. As for the shareholders loans that she claimed were owed her, 45,000 of that, approximately 45, came from the 2016 tax return. The balance came from the 2015 tax return, the document that was clearly in evidence at the time of trial. So following the October 12th hearing, the husband concluded with his own testimony. And he made a prima facie case for the contempt, for sanction, for failure to comply with the safe harbor provisions. And then the former wife filed the motion for enforcement and motion for set-off. Those hearings drug on for 2 more hearings and required the testimony of Mr. Alcorn and, well, the person who used to be the party's CPA, Mr. Thaney. In the end, the court ruled that the former wife had to repay or had to pay the $61,027, and she had to pay the sales tax, all with interest. If there was a ruling that she had to repay interest, there was nothing in the record saying why she had to pay the interest, if she had any grounds for withholding it. And had the court made the required findings, whether her withholding was intentional, which it was, whether she had the ability to pay, she did, because she had sent the entire amount to her attorneys who were holding it in escrow or in their trust account. And if they answer those two questions in the affirmative, then she was in contempt of a lawful court order. I'll ask for the motion for sanctions.
I'm sorry, that was your time.
Okay.
It's your time and you can continue to use it, but you're at the 5 minutes if you want to save.
I would like to save the 5 minutes, Your Honor.
Okay, all right.
Thank you for interrupting me.
Okay. I always feel terrible doing that, but I know you probably want to keep track of your time.
I was trying to, but I was getting a little nervous.
I understand. Mr. Tarnow, are you ready?
Yes, Your Honor.
All right, we're ready.
Thank you, and may it please the court. My name is Ryan Tarnow. I was with the attorney for the appellant in this matter, and I was also one of the attorneys at both the hearing and the final trial. Concerning the matters before the court, I would first like to recognize the issue concerning the judicial notice. Pursuant to the court's instructions prior to our filing of the answer brief, we were told to include the information in there. Ms. Poland's representation concerning the prior records do not indicate compliance with statutory provisions of written notice. The court was not provided written notice of prior records being used at this subsequent hearing, which is the purpose for our representation. That reliance on those records for the purpose of this appeal is not appropriate. If Ms. Poland intended to use those records, it needed to be through the statutory scheme, which is 90.403 and 404, which requires written notice, timely written notice. That was not provided. In terms of the claims presented in the substance of this matter, I would first like to point out that there are multiple representations being made that there was no written request for the set-off or the issue concerning the amount of the shareholder loans being made prior to the hearing in October of 2018. That is actually factually incorrect. If the court looks to the record, specifically our response to the motion for sanctions, record page 7874, there is a specific line at line 2 on the top of the page, which makes a request for the set-off. So this was prior to the hearing, and at all times we made this representation that we were, or at least my client was entitled to the shareholder loan. The continuous representation by appellant that was never stated prior to the hearings is incorrect. We at all times, and including letters which were sent, and also all of it included in the response to the 57-105. At all times, we maintained that position. Subsequently, we filed a motion to enforce that was added on to the subsequent hearings. But at all times, we were requesting the repayment on the shareholder loans. As for I believe the statement concerning the judgment interest that was provided in the judgment, the reason the lower court provided it was because it was requested in the motion to compel, which was granted. And I'm referring to the record, which is page 7764. Appellant specifically requested judgment interest from the date of the final judgment until paid and set date certain for the payment, which is why the hearing court provided the judgment interest. He was going by what was presented in front of him, which was the motion to compel, motion for contempt, and the 57-105. Now, in terms of the attorney's fees and costs, it is important to note that out of all the motions presented, only the motion to compel was granted. The motion to compel does not request attorney's fees and costs. The motion for contempt, the 57-105, and our motion to enforce are the motions that were requesting attorney's fees and costs. All of those motions were summarily denied. There was no requirement by the hearing court to make findings pursuant to the attorney's fees and costs if he did not find entitlement. If he found for entitlement to attorney's fees and costs, then he was statutorily and by case law required to make findings for reasonable compensation of the fees, need, ability to pay, hourly rate, and amount. That is when he was required to make those findings, but he denied all the motions outright. And with concern with the request for findings by Ms. Sutherland-Poland in this brief, the problem is that is not how 57-105 works. 57-105 states that there must not be any justifiable fact or law. If there is no justifiable fact or law, then the motion for 57-105 succeeds. The hearing court found that there was a justifiable fact in the position that we took. And that was based upon the issues not between counsels or the parties. Where the court looked to was the difference in opinions between the accountants. And actually, the judge took the effort to provide the discrepancy in his opinion, which was there was Mr. Faney, who represented the appellant, and Mr. Nesbitt, who was representing the appellee. Mr. Nesbitt, and again, I would point to the record, which is page 7874. Ms. Poland is trying to assert that it was the tax returns that provided the problem with the shareholder loan. And as we represented here in our verified response to the 57-105 pre-hearing, it was actually the book records and K1s provided June 5th, 2017. So what we found out at the hearing was appellant personally and through his counsel instructed Mr. Faney to wipe out the loan. It disregarded tax procedures and it disregarded the agreement on the company side. The company had not been changed over at the point in time that the shareholder loan was wiped. The monies that was recognized on the K1 pursuant to the tax code had to be paid to Ms. Alcorn. What Ms. Poland is suggesting is that prior to this final hearing, there never happened. At least this transfer of money did not occur. That again is inaccurate. In fact, we had multiple weeks at the final hearing and the trial court in the final judgment provided an exceptionally lengthy opinion pertaining to Mr. Alcorn's claim on the monies that were being transferred out of the company into Ms. Alcorn's personal account. The trial court disregarded the claim of Mr. Alcorn and found for the appellee in this matter. That issue was not brought up on appeal. It was held as a final trial order. In terms of the sales tax issue, I would also again point to the record, we proceeded with the following at the trial level. The trial court made an oral pronouncement advising that appellee's accountant, Mr. Nesbitt, was to do the sales tax audit. I agree with Ms. Poland, it did not transfer to the final judgment, but that does not make it an invalid belief that an oral pronouncement of the court would still remain valid. That being said, Ms. Poland, in fact, during her cross-examination of Mr. Nesbitt, pointed out the basic issue with our concern with the sales tax audit. Mr. Alcorn was not recognizing the total receipts that the business was getting, which was the subject of the sales tax audit. And I would refer to the record on pages 8344 and 8345 to show the issue concerning the sales tax audit and why we could not trust the number being provided by Mr. Alcorn. We were not sought out to help with the sales tax audit. We were not sought out to be brought in for our opinions on the sales tax audit. Mr. Alcorn elected to take it upon himself, which was not a requirement of the final judgment, and create his own number to his own benefit. Whether that amount was higher or lower is not the relevant question. It's whether it is an accurate representation to the state of Florida. That was the position that we took at the hearing and was accepted by the trial court because it was not brought up in the opinion as an issue concern to the court. So with respect to this order, I would suggest to the court, there is also no res judicata. The final judgment provided a procedure in terms of the buyout. Now, in that same paragraph where it's referencing the buyout provision, at the very beginning, the trial court makes reference to the shareholder agreement. So the trial court judge was referring to the shareholder agreement when he was creating the process of a buyout. It was our opinion and our belief at the hearing that if the trial court judge intended it to just be a simple transfer, it would have been done so. But the recognition of the shareholder agreement in the same paragraph provided us the belief that the buyout procedure was to be done pursuant to the agreement. We then knew the tax issue, the tax code issue, which was presented by Mr. Nesbitt to the court. And the hearing court recognized that Mr. Nesbitt's argument was correct because Mr. Faney also recognized that there were significant discrepancies in what the books and the K-1s were showing. And to an individual outside of the context of their unit, Mr. Nesbitt's representations were accurate. So that is why the trial court provided a one little paragraph where it says, I give Mr. Faney a little bit more credit because he was familiar with the actions of the parties. But what I find is that Mr. Nesbitt was not wrong in his position that the appellant took, which is why the 57-105 did not proceed. And the other part to the 57-105 is that it was a multi-tiered issued motion. So all of the other issues on that 57-105 were resolved prior to it being submitted to the court. Appellant did not amend or issue a new 57-105. Because of that, the 57-105 had at least majorly based on the contents of the motion been resolved. The motion itself was moot, and to proceed in the motion in its entirety goes against 57-105 and the safe harbor provision. There must be no justifiable fact or issue of law. The minute that Ms. Alcorn complied with the majority of that motion, the motion on its face could not survive a 57-105. And if there is an error by what the hearing court did, it was that Mr. Alcorn, as the losing party on a 57-105, was required to pay appellees fees. So there is the error. It is that Mr. Alcorn was required to pay Mrs. Alcorn fees for pursuing the 57-105. We did not bring that up because we're just trying to resolve this in its entirety. But if Ms. Pullen is going to come in and say the 57-105 is an error, the real error is that the hearing judge did not give Mrs. Alcorn her fees when it found that she prevailed on the 57-105. And again, the res judicata, it does not apply because the issues pertained to actions required by the final judgment post-hearing when it required a procedure for the buyout. All of the testimony and all of the facts relate to the procedure, not to the substance that was provided in the trial court. The provision in the actual opinion required Mr. Alcorn to be responsible for the costs associated with the buyout. The position that Mr. Nesbitt presented was that the tax code requires the final K-1 to be issued. the amount of the shareholder loan, which is the capital account, needs to be paid out to the exiting partner. That's pursuant to the tax code. And based upon the representations by Mr. Thaney, it was the appellant and the appellant's counsel who instructed the accountant not to give that money to Mrs. Alcorn, to wipe out the shareholder loan, which was never done prior to what Mr. Alcorn did. And I would ask that the court find that the hearing order was accurate and uphold the order. Thank you.
Thank you. All right, Ms. Sutherland, you have about 5 minutes left.
Thank you, Judge. I'm unmuted. Okay. One thing in rebuttal that's very important is there was never any testimony that Mr. Alcorn instructed Mr. Thaney to wipe out the loans. Mr. Thaney carried out the process in 2016, just as he had carried it out in 2011 through 2016. In 2011, Mrs. Alcorn set up the structure, not Mrs. Alcorn. That was the clear testimony. Even if there was a pronouncement in court that Mr. Nesbitt would participate in the audit or could participate, that never made it into the final judgment. If the appellee objected to that provision not being in the final judgment, they should have raised it on a motion for reconsideration or on appeal, not subsequent to this court, subsequent to the final judgment being entered and becoming final for lack of appeal. And one more thing, Mr. Opposing counsel, Mr. Tarnow, said there was a procedure for a buyout in the final judgment. There was not a procedure for a buyout in the final judgment. I think it was the specific language was cited in the briefs, and so I will trust you all to read that and to understand what that says. But when you do read it, the interpretation given to it as being a procedure is ludicrous. The word buyout is used only in this paragraph, and it's only used to describe transferring the asset. Now, on the sanctions, there was no justiciable basis in law because these items were barred by res judicata and set off. The trial court had an obligation to rule on these and had an obligation to make findings of facts and conclusions of law, cannot be doubted. I refer you to the Wigington case that's cited in my brief. If the court finds there were no factual basis, as the trial court found Mrs. Alcorn had knowledge of all of these practices. And if it's true that she had that knowledge, then it cannot also be true that there was a basis in fact. Those two things cannot exist together because they are diametrically different. And so I would ask your honors to rule de novo that the trial court had an obligation to make these conclusions and findings of fact, that they failed to do it, to make the proper findings and conclusions because it was an error of law, and the proper ones being that there was no basis in law, no basis in fact, and Mrs. Alcorn was in contempt of court, and to remand it for a hearing as to attorney's fees and costs on behalf of Mr. Alcorn. Thank you.
Okay, thank you both. We have 2 more cases left on our docket today. We are going to take a 10-minute break and we will be back to call those 2 cases.
Thank you, Your Honors.
Thanks.